Yeah, the people had filed an emergency bond violation when we asked the court to issue a bond and issue an immediate court. So I checked Exhale. He's not in custody. I don't see him present. I have no idea where he is.
Is he here? Where is he? Where? You need to come up. I'll call your case. Court calls case People versus Henry Carter.
Well, you are John. This on behalf of the defendant who's going to come, right?
All right.
Come on, Carter.
All right. We're going to deal with the bond hearing first and then decide if we're going to go with this case.
Okay. The people sent in that motion because I was going to keep it myself. There's 3 police reports made. 1 made to Romulus Police Department and 2 made to the Wayne County Sheriff's Office. I'm still awaiting the police reports from the Wayne County Sheriff's Office, but I received the Romulus Police report and attached it to my emergency motion. There was text and things that were said by the defendant threatening me. When I spoke to her on the phone, she said she was extremely concerned for her safety, and I had to hear those concerns, which is why I filed a motion. I'm not sure why Mr. Carter has not submitted this warrant I would ask that the bond to be set at a very high rate. We would have a court and fourth remaining both. Those are 3 different violations of bond. He also has he has the no contact. He has the no go to that we have this in this case, and so I don't understand what the reason to reach out for any reason.
Mr. Vince.
Well, Your Honor, is the witness here? Because that is all. I mean, all the allegations are based on her word. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged.
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
so you want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. And I'm also waiting for the actual screenshots of the text messages that are written in the Romulus Police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
Now, in that police report, there are 6 phone numbers. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff Department police report would be any different than this. As far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence, no third-party evidence, and frankly, if you read through the report,
I did. Before I revoked your class bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie, or he's the luckiest guy on the planet, because I would think that Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, and generated somehow, all while outside, 6 other phone calls from 6 different numbers none of which line up the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Well, you know, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate. There's just simply, there's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses. None. Wait a minute. He's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Oh, you know, without a witness, without some shred of physical evidence, there's nothing. This is just an allegation of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting his final settlement conference where he's charged with domestic violence. He's also on bond awaiting pre-trial where he's charged with child abuse court. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third. Mr. Vincent claims that he knew nothing about screenshots, so I just said on the record I don't have them, I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he could read that report. Also,
Your Honor, I don't have screenshots.
You not ever. I let you go on and on. I told you what I'm trying to focus on. Keep trying it, Mr. Benson. You're going to run into trouble real fast. Ms. Kirby, you may continue.
I also explained in my motion that the Romulus police report is different than the two other contacts this victim had with the sheriff's department. I included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus are here. No, it's completely different. And I don't have the accusations in those. I'm waiting to get those, given that we're not in our county and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and do a return so I can get the other police report, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked. And he needs to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this serious at all, which also is the case. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out, no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court, but she is not present. And regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway, so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing.
Now hearsay, allegations. Someone's not here. This all happened in the last 48 hours, 72 hours.
Keystone is not here, but if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to body language. So that maybe we can clear that part up. Because, so they don't need her. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a...
That's not your issue. They've made the representation to the court.
Okay. And I'm making a representation to the court that when you read the police report, which you have...
I read it.
Then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availing himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today? Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to the question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
Right, that's correct, Your Honor.
That's a wrong answer. Way the wrong answer.
I'm sorry.
I'll deal with this in a minute because right now I'm furious, Mr. Benson, that you would represent that you client defendant for me. Take it. Court's going to stand in recess. Maybe please. Yeah. Can you bring him? Somebody back there with him. Can you bring him back? Court calls the case of the people versus County Federal. Recall.
Now, that's on the offer of the defendant. Yeah, there was absolutely a mix-up. In as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have been, absolutely a mistake on my part.
Well, it's not a mistake, it's a sanction. And I think you ought to know that to willfully tell a client, or even to intimate to a client, they should in some way disobey a court.
In no way, shape, or form, Your Honor, did I have that effect. My understanding was that he had seen you in person this week, and that I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor. This is a horrible mistake, and I'll fall on my sword for it. But it is a misunderstanding. It's not any, in no way, shape, or form was I trying to get him to avoid justice. He certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week, and that he was free to come here Friday. We clearly had, at no point did I ever advise him to do anything else other than follow the law. I must have told him that a dozen times, and that every time I'm talking to him, do not violate your bond, don't violate your bond, show up Friday. When we have a court date, my understanding was that was the understanding. It was absolutely a snafu on my part, and I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselors trying to get his CDL and take care of his kids. He is working on another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then, too. He understands this is serious, Your Honor. Just vehement in, then I perhaps have been overzealous on my part. I meant no disrespect to you, or to the people.
What I'm going to do in this case, because, something's got to be decided as to what was told to the defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. And then
Yeah, my echo.
I don't think you want to do that. I am just.
No, you know I mean that.
Ashley Londy for the people.
First Assistant Public Defender Queen Anderson with it on behalf of Mr. McGlashan. Mr. McGlashan, can you state your name again, please?
Brandon McGlashan.
Your Honor, thank you again for the bench conference. At this time, the people are going to move to revoke the defendant's bond based upon the no contact violations that he's had with the victim in this case. I have previously disclosed to defense counsel the nature of the contacts, and there has been a new aggravated stalking case issued by my office that is in the process of sort of being sworn out and will be pending against the defendant soon. The defendant did have permission from circuit court to contact the victim regarding their child. However, the court has reviewed and has been submitted a police report that details the contacts he's had with her, which the people do believe go well past the scope of communications regarding the child, and are requesting at this time that he be remanded into custody because people have serious concerns that he will not leave the victim alone. He will continue to contact her, and while there is no threatening or violence alleged in any of these contacts, the people would certainly characterize them as harassing, and I do believe that it is appropriate at this time that his bond be revoked and he be remanded into custody. Thank you.
Response.
Thank you, Your Honor. In speaking with Mr. McGlashan, and we would indicate to the court that Mr. McGlashan does have permission to contact the complainant in this matter with regards to the child. A substantial amount of the conversations are about the child. They are to be, there's some communications to be made through the My Family Wizard app, but he was allowed to make contact via text if there was some emergency. There were some situations, without going into too much of an admission, but there was some situations where she was not responding on the Family Wizard. There were texts to get her to communicate with regards to the child. We would again reiterate, as we discussed in the bench conference, that there's no threatening behavior, no threats being made towards her, or any discussion about this particular case or anything to involving the case. My client has been the primary caregiver of the child, and while some of the things may not seem to be an emergency given his relationship with the child and him being the primary caregiver, he had a heightened sense of concern with regards to some of the things that were being discussed. The parties are currently in divorce proceedings. It's my understanding that they are trying to come to some resolution, and that my client is really just looking forward to moving forward, caring for his son, and continuing to work. Your Honor has given him permission to leave the state. He is out of state right now. Is set to return on Saturday. And he does have another job where he will be working as an announcer at the water polo tournament on Saturday and Sunday at the University of Michigan. So he is just asking for the court's consideration with regards to this. We've had substantial conversations as to how he is to handle any contacts that are made to him, and that he is not to respond. He's to get in contact with my office and allow us to deal with it without him responding. He understands that he's the one with the case and the PPO, and that any contacts will fall on him. So he's just asking for some leniency from the court to be allowed to continue working and taking care of his child, and would ask that we adjourn this matter so that I can get the new case, see what's going on with that, and move forward.
Ms. Anderson, is there an opportunity for you to speak at all during this? Because
Mr. McGlashan, if the judge gives you permission, you can speak, but I would advise you not to speak about anything involving either case.
Sir,
even if
you can tell me. I mean, you can tell me what you want.
Okay,
your
sir.
attorney gave me her advice.
Yes, she did. Your Honor, I'm not incriminating myself in any way here. I am verifiably, provably the victim of domestic violence from the person who got the PPO on me and kicked me out of my house. Miss Lundy, the DA, is the one who received that evidence and gave me a very cold and short answer when I asked why my attacker was allowed to stay in my home and get a PPO on me. At the PPO hearing where they received the PPO, I got into evidence and a FOIA request that my wife does in fact have a violent history, including a no contest plea and 2 arrests after that.
Sir,
No, I'm just saying, sir, she lied to kick me out.
Stop.
I'm sorry.
Let me just stop you. Because here's what I understand. You, as to the child or children in common, you had been directed by the family court to only make contact with through my family wisdom.
Yes, sir.
And that the only exception to that was then if it were an emergency.
Or time sensitive, yes, not necessarily an emergency, but time sensitive regarding pickup or drop off or something that needed to happen when she was dropping the kid off. Like, make sure he brings this or that because we planned on doing this, that kind of thing. If she's not answering, I would literally sent OFW, and I'm an idiot. I shouldn't ever respond to anything, but I feel like
sitting judge. Hold on.
Yes, sir.
You wrote to her. The sitting judge signed a protection order.
She wrote that to me, sir.
Hold on. That I acquired evidence that you were lying to get the PPO and to throw me from my house. And I literally gotten those documents that afternoon before you would not have gotten the order, and you know it. And just to be clear, I've gotten video transcripts of every hearing so that we can remind the judge of everything you said and done, and that she's not just relying on my memory. Sir, as
Yes,
to even the parameters, because I'm going to give you a shot to tell me, and there are more.
I know, sir.
To explain to me, in your mind, how that fits into the sort of expanded parameters that the family court gave you over our parameters.
Honestly, sir, I don't really have a lot to say about that. I was just trying to explain my
I
mindset.
don't want. Tell me, sir.
You said how my mind.
Answer. If you want to talk to me, then you'll answer my question. Because I'm trying to figure out. First of all, you were supposed to have no contact according to our case. That gets expanded because you're in these family court matters. The judge in the family court, everybody's in agreement, he said no contact except through my family wizard, and the only things outside of that are to be certain things. What I just read you, tell me how that fits into any of those things that constitute an exception.
I just honestly believed as a victim if I screamed the truth loud enough, someone would come to my rescue. I don't know the system. I don't have a lawyer.
But that is not. Hold
Yes,
on.
sir, I am.
That's not. That can't be a purpose for you contacting.
I misunderstood the framing of the question. I'm sorry. I
The
just
framing
honestly
of my question that I've said twice.
No, sir. Oh, sir. I'm sorry. I'm very sorry. I don't mean to agitate you. It's been a very
I
long
am
year.
not agitated. I'm just trying to figure. I'm trying to give you every opportunity to explain to me some of these text messages
Yes,
and
sir.
how they fit within. You're before Judge Vandenberg.
Yes, sir.
How these fit within what Judge Vandenberg told you could do.
I'm not 100% sure I can make a great case for that, sir. I've just been very willful and heartbroken and defiant, and I'm sorry.
Okay.
It will not happen again.
Sir, there are. That was like one of the shortest ones. I don't
Yes,
know
sir.
what your legal fund has to do with an emergency.
With my legal what, sir?
Your legal fund that somebody's created for you. I don't know why that's an emergency.
Sir, I realize now through therapy that some of those things that I thought were things trying to get my wife to tell the truth before we had to come into this madness seem more manipulative and threatening than I had intended them to. I understand that. I'm working very hard to reframe things like that. All that stuff is literally just me
Yeah, but
trying
this
to
was after. Hold on. No. As I understand these emails, these text messages, these are occurring after everybody's told you what to do.
Yeah, I'm not disputing that, sir. Again, I'm trying to answer the question, but I feel like the question is changing as I answer.
No, my question's not changing. I'm trying to figure out.
It doesn't fit.
Sir,
It doesn't fit. There's a delay.
if you want me to go through all of these and ask you for your explanation, I will.
I understand now what you're saying. Sir, I just want to do better. I have no explanation other than it's not an excuse. I'm just heartbroken and I was trying to keep my family together and I'm not good at it. It will never happen again.
Mr. McGlasson, again, I'm going to advise you just not to say anything further. It's not furthering our goal.
Okay. I just want to do better. I'm sorry.
I'm going to adjourn this matter 1 week out to the 9th, 2023, 9 a.m., where defendant's Zoom invite indicates. As the court, having reviewed the text messages, understanding that it would be consistent with what Judge Vandenberg does, knowing the circumstances, allowing for emergencies, or even is giving the defendant here the benefit of the doubt, those things that are time sensitive. I read one example, but there are a number of examples to this thing that are not time sensitive. They certainly, in this court's mind, don't constitute at all an emergency. And quite frankly, and I get what counsel's saying in terms of rats, maybe a physical harm or something like that. But quite frankly, when I read through these, they are threatening. They're threatening, phrase it maybe in terms of harassment, but they're really threatening in terms of getting a response.
Yes, sir.
And I mean, the other person on the other end, you want to keep talking? I'll let you keep talking.
No, sir.
It's up to you. It's up to you. I'm going to give you every shot to tell me what you want me to know.
I don't want to get in trouble, sir. I'm not trying to make you angry. I'm sorry.
I am not angry. I am trying to give you every opportunity to tell me. I just don't like being interrupted. But that doesn't make me angry. So, go ahead and tell me what you want me to say. Because once I get going, I don't want to be interrupted.
I promise.
So you go ahead.
Yes, sir.
Go ahead. Tell me what you want me to know.
My answer to every question will just be simply this. I naively thought that if I can prove I am the victim of an assault and being kicked out of my house, that none of this would matter, that it would all just kind of be voided from the point where I can prove she lied and I'm an idiot. I'm sorry.
You done?
Yes, sir.
Bottom line, these don't constitute emergencies. They don't constitute something that needs a direct response or an immediate response of her or would be time sensitive. They are really an attempt to get someone to say something. They're actually like baiting types of emails to get her to maybe say something or posturing maybe for his divorce case. That's not the purpose, certainly, of Judge Vandenberg's order. If, even as the defendant says, I wanted to get somebody to listen, I don't think she's the one that needs to listen. If he thinks he's been the victim of something, then he needs to get it to the prosecutor's office, police, whoever the heck he needs to get it to.
But
there you go. There you go. What did I tell you? I'm done. I kind of tried to give my explanation. This defendant won't be quiet. It's March 9th, 9 a.m. Defendant's bond is revoked. Sir, when are you returning to the state of Michigan, or do you want me to come get you?
I will return Saturday morning to work at Michigan. Can it be Monday morning?
What time? What time Saturday morning?
I think my flight gets in at 9:25 or something. I have to work at
Defendant's
12.
bond is revoked, as indicated.
She beat me.
Defendant is.
How is this possible in America?
Defendant is to turn himself into the Washington County Jail by noon this Saturday, which is the 4th. And sir, what I'm telling you, so we don't have to play around the edges of what I mean. If it's 12:01, you're going to have a problem.
Yes, sir.
12 noon. If defendant fails to return himself in, a bench warrant will issue for his arrest and he will be held without bond. Told you what rules I play by. You still wanted to interrupt me? I'm telling you the rules now. Try me. Thank you, counsel.
I thought you were done. I have a delay on my phone. I thought you were done. There's a delay. I'm in St. Louis.
He's still talking.
I wasn't interrupting. I'm in St. Louis.
I'm done.
Mr. McGlashan,
done.
just log off, Mr. McGlashan. We'll talk later.
So who wants to go now?